Good morning, everybody, and welcome to the Law and Crime Network. I'm Jesse Weber, joined here by Law and Crime trial analyst Dan Schorr, and thanks for joining us here on the program where we cover the most interesting live trials and legal stories in the news today. We have a lot to cover, so let's get started right now. Now, we have an update for you in another case that we've been covering here on the network, the saga of Chris Watts, the man who pled guilty to killing his entire family, his pregnant wife, Shanann, their two girls, Bella and Celeste, and he also pled guilty to the unlawful termination of his unborn son, Nico. Just a tragic, ultimately brutal case. And you know what's so surprising? Even though he pled guilty and he's currently in prison serving multiple life sentences, we are learning more details about what happened. In fact, Shanann Watts' family's personal attorney spoke out on Dr. Phil about some gruesome details in this killing. Take a look.
The night in question, Shanann came home. She and Chris got into a fight. They had made up. They were getting along quite well. Later on, they got into a fight again. In that fight, he essentially confessed to having an affair, that he wanted a divorce, that it was pretty much over between them. And she had said something to the effect of, well, you're not going to see the kids again. As a consequence of that conversation, he strangled her to death.
They have this argument, and she threatens you're not going to see the children again, so he attacks and kills her. Did Bella witness any of that? Did she walk in while he was wrapping her?
Bella walked in and asked, "What are you doing with mommy?"
Wow. Joining me again right now is Law and Crime trial analyst and managing director at Ankara, Dan Schorr. Dan, how would this attorney, who's the family attorney for Shanann Watts' family, how would he know these details?
Obviously someone must have told it to him because he wasn't there, so it's very strange. It's also this new phenomenon where people are, instead of going to law enforcement, they're going on TV and talking about really important facts of cases that are still pending, still going on, might then be in an appeals process. So it's really unclear how this information was received and then what's going to happen with it.
I'll tell you one thing, it's just we want more information about this because we want to understand how this happened. Even though it makes no sense, that's the thing that people are drawn to, I think, most about this really horrible and chilling case. I mean, why would a man just kill his family like this, and how did it go? How did it happen? So we are obviously going to bring you more details about the Chris Watts saga whenever we have more information here on Law and Crime. But right now we're going to switch gears. We are live right now in the Nouman Raja trial. So let's go live into that courtroom. First witness is on the stand. Okay, so Dan, the reason we see the first witness here for the defense is because the judge denied the defense's motion for judgment of acquittal. You surprised by that?
No, that's pretty standard. The prosecution rests their case. The defense always makes a motion to dismiss, saying that even if the evidence is viewed in the light most favorable to the people, it's not enough to make out a case. That's a really hard thing for the defense to win on, and they didn't win here.
Does it ever work?
It rarely works. The only time it ever works is if an element of a crime wasn't established by any evidence, and then the judge may throw out that crime. But that's very rare, and you don't really see it. It's not based on credibility. It's not based on persuasion. It's based on, does the prosecution make out every element of every crime?
We know that they lost the stand your ground hearing, so as a matter of law, it had to go to trial. They can't get it dismissed as a matter of law. It's going to all be in the hands of this jury, and it's not an easy question, I'll tell you that much. Let's take a quick break. When we come back, we will be live in this courtroom in Florida. Stay tuned. Okay, Dan, so you tell me, what should we be looking at right now? Like, what should be the testimony that would really help the defense's case if he's constructing the crime scene to show that, you know, this was self-defense? What would be the things you'd be looking out for?
Right. The defense is trying to show that this was self-defense, that he acted on a threat to him or a perceived reasonable threat. So where were the bullet wounds? Where were the bullet casings or any evidence of gunshots? Where did they occur? The spacing of them. There's a difference between him firing 3 shots and then being a pause and then firing 3 shots again. a delay that's less of a self-defense, or other evidence that might show that it was consistent with him seeing a threat, acting on that threat in a quick few moments. So that's a big difference in terms of whether he was reasonable in his actions.
I think it's been pretty established that Corey Jones was running away at a certain point. I mean, he was a distance away from his own car. How does that hurt the defense? How does that help the defense?
Not only running away, but one of the bullet wounds, according to the prosecution, was in the back of his arm. And that's critical, because you can't say it's self-defense if someone's running away and you shoot them in the back of their body. If that's true, it's hard to explain. Why would it be self-defense if the person's running away?
But the strongest piece of evidence for the defense is the fact that Corey Jones did have a weapon on him.
He did have a weapon, but he had a license for that weapon. And if he drew the weapon, which it seems like he did, that might have been reasonable, because the defendant here was a police officer, never identified himself as a police officer, even though he said that he had. The audio tape that was available shows that he never identified himself as a police officer. So the victim here was alone in a secluded area, dark, and he might have been afraid.
Well, playing devil's advocate, the defense will say he did identify himself as a police officer, just wasn't captured on that audio recording, because the first thing that you hear on that audio recording when the defendant shows up is you hear Corey Jones say, huh? So he wouldn't have said, huh, unless there was a question directed at him or some statement directed at him from Raja. The defense will say, he said, hi, I'm a police officer, do you need help with anything? And according to what we hear in that audio tape, it's not clear, it seems that Jones didn't know what was going on.
Well, the defense can make that argument, but it's clear that his story originally about how he identified himself as a police officer is different than what's captured on audio tape. And they acknowledge that difference. That's why they had the first witness testify about how officers involved in these kinds of incidents sometimes recall things differently. Doesn't mean they're intentionally trying to lie. So they acknowledge there's a difference between the story he first gave and what's reflected and what really happened.
Yeah, we're waiting to jump back live right now. This is a defense witness, a crime scene reconstructionist called by the defense. Let's go back live. All right, let's break out right now and get some perspective. And also joining me is, of course, federal trial attorney Kelly Hyman. Kelly, great to have you here on Law and Crime. I want to ask you with a very easy question. I want to start. You think the defendant is going to testify? Because it's going to happen. It may happen today.
Absolutely. I do not think the defendant will testify. Of course, it's right for him to testify if he feels that there's a need to, and the jury can't hold it against him if he doesn't testify. But if I'm a betting person, I would say he doesn't testify.
Now, I got to tell you, Kelly, I'm a little surprised by that, because I think in these kinds of self-defense cases, we usually see the defendant taking the stand and talking about this. I mean, it doesn't always work in their favor, but in these self-defense cases, don't you have to have them testify?
I think it's a very good point that you bring up, Jesse, for the fact that for him to testify. However, sometimes they make a decision not to testify. So ultimately, it'll be interesting to see what happens. But I think that he won't testify.
Dan, let me get your perspective. Thoughts, comments, concerns? What do you think?
Yeah, it's a tough decision. I think he would generally have to testify, because otherwise, how do you make out a self-defense claim without him asserting that there was a threat to him and he acted on it? I think one of the risks here is there are some inconsistencies in his earlier statements, and it seems like what happened and what was captured on audio, he's going to be confronted with those inconsistencies. That's a reason not to testify. But I don't see how you get across your self-defense claim without actually explaining it.
Well, that's not the end of my questions. I got a lot to wait to see if this man testifies and what could ultimately happen. But we're going to take a quick break on our end, and when we come back, we will be live in Nouman Raja. Stay tuned. All right, Kelly, before we begin cross-examination, you tell me, what did we learn from direct examination of this witness? I mean, what did the defense try to get out?
Jesse, I don't think the defense was, very effective in what they did. And I don't think that, honestly, that the jury's got much out of this witness.
It's interesting. I'm trying to figure this out. I'm trying to see, Dan, they're trying to say reasonable doubt. He was acting defensively. This was self-defense. I mean, what did we learn from the way the gunfire happened?
There's nothing obvious from that testimony. Sometimes the defense attorney has a theory, and later on they're going to call other witnesses, and they point back to other evidence, and they show how it leads to a conclusion, and maybe that's what's going to happen here. But there's nothing that jumps out there. Although it does show the defense is taking it seriously, putting forward experts, that there is a law enforcement person on their side. It's not just the prosecutor who is law enforcement, so it's also setting that tone.
And I think, okay, cross-examination has just begun by the state, so let's go live, and maybe we can learn a little more. All right, Kelly, let's start with you. What is the state saying? That he's biased because he's getting paid to do this work?
Absolutely. It goes to his credibility, the fact that they pay him a certain amount of money, and also the fact that he really didn't answer the question. It was very interesting when they asked him how much he made per hour. He said basically, oh, ask the office people, rather than just say, listen, I get paid $2.50 an hour.
Yeah, I mean, we see this a lot, don't we, Dan, where they show bias based upon that. But I'm curious, your perspective, what's the meat of what they're trying to get at now with this cross-examination? What are they hoping to say, poke holes in his testimony with?
Well, they're trying to show what was done, what wasn't done, and it's unclear where they're going from there, but they're certainly setting the scene for, was there a search for blood, where were the bullet wounds, things like that. And they established not so much that he got paid, but that he wasn't really forthcoming about it initially, and as Kelly said, that hurts him, because you want the jury as a witness to feel, I'm just telling you everything. I'm answering any question openly. And to say, how much do you earn? Well, you have to ask someone else. When you really know, that doesn't look good.
And I think at the end of the day, we might not have a clearer picture of what happened with the shooting. I mean, again, it wasn't captured on video. It was captured on audio. And it was very strong audio where we may have a sense of what happened. But based upon everything we've heard, it's really going to be up to the jury to determine what really happened on that day. So let's take a quick break on our end. When we come back, we'll be live in Nouman Raja. And clearly, there's a lot to discuss. So stay tuned here on Law and Crime. We'll be right back. All right, let me get some perspective right now from federal trial attorney Kelly Hyman. Kelly, I think what the state is trying to do here is saying that, is it that he wasn't thorough, that his analysis really didn't tell much more of anything? I mean, what are you getting from what they're questioning him about?
That's a great point, Jesse. What I'm also getting is they're poking holes at his testimony, basically showing that he can't prove what he says that he's going to prove. And I think that the prosecution is doing an excellent job with defense experts.
Yeah, well, we're going to have to see ultimately what the jury thinks. It's all in their hands to determine who's credible and what they believe. Let's take a break. When we come back, we're going to be live in Raja, and clearly there is a lot to discuss with each witness, and we're waiting to see if the defendant will take the stand. So stay tuned here on Law and Crime. We'll be right back. Okay, sidebar right here gives Dan Schorr and I some time to talk. And Dan, of course, is the Law and Crime trial analyst here on the network, as well as the managing director at Ankara. Dan, I want to just say, what are we expecting today? The defendant taking the stand. I mean, he's got to go on and explain, hey, I understand what I said might not have been accurate when I first did that walkthrough. My memory was mixed up. I mean, what is he going to say if he takes the stand today? Well,
he has to give his version of events that's consistent with self-defense, which would be that there was an imminent threat of deadly force or something similar, and he acted in a way that he had to act. That is not something that the evidence is showing right now. I don't see how the defense gets that into evidence unless he testifies.
And you need that human face on the defendant in a way, hear him speak. Let's go back live. Questioning has resumed. Dan, I think one of the most alarming things we learned from this testimony is that it's corroborated by the fact that Corey Jones was not only running from the defendant, but I think he was 30 feet from the car behind the SUV when the first shot was fired. Again, doesn't sound like self-defense.
Right, and the defense witness is acknowledging that they were moving away, that the victim was moving away from the defendant, and he was disputing whether it was fleeing or chasing, but he acknowledged they were moving in the same direction, which was away from the car. So how is that consistent with self-defense? You also have the injury, the bullet wound to the arm that's in the back of the arm.
Then again, if he's holding his own gun and he could be in a position where he's blocking himself from gunfire, you could make that argument, couldn't you? You can make the argument that, yes, he had a weapon on him, so it doesn't really matter where he was positioned. He was in a position of hiding.
Yes, but first of all, this is all inconsistent with a lot of the statements that the defendant made when he was giving his first version of events. So,
right.
So no matter what it shows, the fact that it's inconsistent undermines the credibility of the defendant when he's offering self-defense.
Right, and let's talk about that, because yesterday the defense did bring out a witness to talk about. He was a medical professional, talking about the fact that a lot of times in shootings, officers can recount details that are just inaccurate because it's a traumatic event. But the prosecution, I think at one point, said you are holding officers to a different standard then. And I'm curious your thoughts on that.
Well, look, people that go through any kind of trauma may recount things differently and may not remember key facts of a trauma. The thing is, all of the mistakes that he made or things that are inconsistent with other evidence all help him. So that's more consistent with someone who's trying to create a story that's going to serve his purposes rather than someone just misremembering different details.
And that's an important point, right? You said it really well. Everything that he recounted helped his version of events, that he was under attack. And I think from 2 days ago when we learned about the laser sight, because he initially said, hey, I saw this laser sight on the gun. There's no laser sight on Corey Jones' weapon. And they tried to do an analysis of whether or not it was light reflecting off of the silver of the gun and something like that.
And that's an interesting thing, because why would the defendant make that up? You could understand why someone might make up whether the person was pointing a gun at him, whether he was fleeing, but why would you make up a laser sight that you didn't see? Because you're going to know they're going to find the gun and look into that. So maybe that is just a mistake that he made, that maybe he did think he saw something, because it doesn't seem like that would serve his purposes to create that. And
let's not forget, I mean, he could have fabricated details that really would have hurt him. If he said, Corey Jones was firing at me, and then they look at the gun and there's no spent cartridges, that would have been a real big mistake. I guess at the end of the day, how does a jury sort through all of this since it wasn't captured on video? And yes, it was captured on audio, but we're trying to get a sense of what happened. What does a jury do?
Well, first of all, obviously the burden of proof is on the prosecution, so the defense just has to show reasonable doubt, and they're going to try to show that. They have to sort through the credibility of the defendant if he testifies, and if not, they have to, if they're going to find for the defendant and acquit, they're going to have to find some evidence that shows reasonable doubt here. The defendant, if he testifies, needs to acknowledge the inconsistencies and say, look, I made a mistake, I was stressed, I went through a traumatic experience, but this is what happened. I felt there was a reasonable threat to my life and I acted accordingly.
There's a 5-minute break in the courtroom. We're maybe going to see who the next witness is. Maybe they're thinking about who the next witness is going to be, because we don't know. So let's take a quick break, and when we come back, we'll see what happens in court. Stay tuned. Okay, so clearly there are things from that interview that don't match up with what the evidence shows, including that laser sight. There was no laser sight. The defense has said, hey, listen, it was a traumatic incident. It's possible that he was recounting details that were inaccurate because, you know, it's not his fault. He's not intentionally doing it. What is your perspective on seeing that video?
Well, certainly the laser sight issue, it's hard to see why he would make that up if he didn't think that existed, because it's going to be confirmed one way or not. But he's not consistent with the evidence that we have about when the shots were fired, whether he was moving and chasing, shooting at someone in the back. Also about whether he identified himself as a police officer. He does give a version of events here, and sometimes defendants don't testify if they have a version that's being played for the jury already, because then they won't be cross-examined. But he probably wants to present it in a more logical way and explain away some of the inconsistencies, and he can only do that through live testimony.
Yeah, I mean, he does say certain details that are accurate. You know, he shot him, there was a chase. But I want to talk about the identification, because this is probably the most important part. If we heard him clearly on that audio recording, the roadside assistance call, I'm Officer Nouman Raja. Is everything okay? Would this have been a completely different case?
It's a huge fact, because let's say the victim pulls a gun here before and that leads to whatever altercation happens. That's not justified at all if someone identifies them as a police officer. However, if he's just broken down on the side of the road in a dark place where there was a history of car thefts and assaults, and the victim had made calls earlier saying he was concerned about that, and then someone just comes at him, and you saw how that officer is dressed. Just jeans, t-shirt, it's dark, it's the middle of the night, with a gun, doesn't identify himself as a police officer, then it's understandable why someone might flee, someone might pull a gun, and then the altercation is started by the police officer. And usually you can't use self-defense if you start a confrontation, and then it's escalated based on something you started.
I think the two biggest statements from that roadside assistance call are, the first thing that he says, Corey Jones, because it indicates to me, if you're sitting on the jury, that he didn't understand who this person was, and hold on. Because if he had taken out his own gun, I'm saying if Jones had taken it and was pointing at Raja, would he have said, hold on? For the idea that makes more sense to me is if he had said, hold on, almost as if, you know, he was being attacked by Raja. I mean, is that a fair way to characterize it?
I agree. The roadside assistance call helps the prosecution. It doesn't help the defense. And the defense might have had a different version of events at the beginning if they knew that roadside assistance call existed. But of course, no one knew it existed right away, except for the roadside assistance people.
And we keep talking about if the defendant's going to testify, and the way that he has to go on is acknowledging that what he said, some of the things in that interview, are just not accurate. But does he also backpedal and say, well, not so fast, I still believe what I saw?
He has to say something that justifies self-defense. The manslaughter charge is based on a negligence theory, for example, and he has to show that what he was doing wasn't negligent, that he actually was acting appropriately based on the facts in front of him, that there was a threat to him, that he was, as an officer who is off, that he was not off duty, but he was responding. He's got to explain why he didn't identify himself as a police officer in a more thorough way. You know, the prosecution saying he didn't identify himself at all. He still has to explain why he didn't make it more clear. There's also evidence that he was told you have to wear something identifying you as a police officer when you're in plain clothes. Remember, he was not undercover. He was in plain clothes. So he still should have had something identifying him physically based on his own supervisor's testimony earlier in the trial. So he'd have to explain why he didn't do that. Why didn't he follow the proper procedures with identifying himself the way he's supposed to? He can try to explain that, and he probably has to.
And he has to probably explain, hey, listen, I identified myself. I didn't know that Jones didn't know what I said. You know, the event happened so fast. I didn't know what he said. I didn't know what was going on. All I saw was a gun, and I opened up. And he initially approached Jones' car because he thought it was a car theft. That's why he was in plain clothes, correct?
Well, he was doing things related to car thefts in the area, and he saw this car on the side of the road. He approached it, but I don't think he gave a really good justification on why he had to approach it in the way that he did.
Right.
Maybe it was someone in distress, as it was. Why would he not think that? But you know, it was an area where there were a lot of thefts, and that's one thing that the victim actually talked to other people about before. He didn't want to leave his car. Remember, he couldn't get assistance. He didn't want to leave his car because he was worried about stuff in the car being stolen.
Yeah, it's just a tragic set of circumstances because it should not have happened, but now we have to see if he'll be held criminally liable. Dan Schorr, thanks so much for coming on. Appreciate your perspective as always.
Jesse, it's always great talking with you. Thank you.
Of course. So we're going to have a lot more to cover, a lot more to talk about. We're going to take a break. When we come back, we may be live in Raja, and we're waiting to see what the defense will do now that the case is in their hands. Stay tuned. We'll be right back.